An appeals court has thrown out the $500 million civil fraud penalty against President Donald Trump.
Now, as a reminder, this ruling, it stems from New York State's 2022 lawsuit against Trump, accusing him of fraud and of exaggerating his wealth. A judge found him liable on those charges in 2023. NBC News senior White House correspondent Garrett Haake joins us now. Garrett, what exactly does this ruling mean? I mean, there's the question of penalty, there's the question of liability.
Yeah, that's right. And this ruling only throws out the penalty portion of this case. The actual fraud finding still remains. But the judges in this case in the Superior Court in New York, which is confusingly the appeals court, not the final say in the matter, ruled that the findings here for what amounted to about $500 million in penalties was in violation of the Eighth Amendment. It was in violation of essentially too excessive of a penalty for President Trump and for his businesses.
Hi, friends. Adam is here. There was a specific moment when the most iconic building in Donald Trump's entire real estate empire came within inches of being seized by the government. Not in a fictional YouTube dramatization, not in a speculative video labeled as entertainment. In real life, in a real courtroom, with a real attorney general publicly announcing she was prepared to begin the legal process of taking Trump Tower, 40 Wall Street, and other flagship properties.
Donald Trump facing this deadline now approaching to secure that $464 million bond in the civil fraud judgment against him. Tonight, authorities have now taken their first steps and what the state attorney general in New York says she is ready to do. Here's Aaron Katersky.
Tonight, the pressure growing on Donald Trump as New York Attorney General Letitia James takes the first step towards seizing some of his assets if he can't meet Monday's deadline to post his $464 million bond. James filing documents to lay the groundwork to take over his golf course in a large estate in Westchester County. Trump's lawyers say he faces insurmountable difficulties in obtaining a bond. 30 insurance companies have turned him down because he doesn't have enough cash, and they won't accept his properties as collateral. Trump says the Attorney General is trying to force him to sell his real estate at fire sale prices. And if and when I win the appeal, they would be gone.
This moment happened. It is documented in the official records of the New York civil fraud proceedings. And the only thing standing between Trump's most famous buildings and the sheriff's office beginning the seizure process was an appellate court stepping in at the literal last moment to slash the bond requirement and pause enforcement while his appeal played out.
New York Attorney General takes step toward seizing Trump assets. The judgments were filed with the Westchester County Clerk's Office March 6th. Public records
That's where his
show.
golf course is. Now,
that's where an estate is.
That's in his estate, and now that it's been filed, if he tries to sell that property, the judgment gets paid first unless it stands behind the bank.
Do you want Letitia James doing this, though, as a Democrat?
I think it's her job to do it if she sued Trump and gotten a $450 or $500 million judgment. Do I want her to do it? Yeah, I want her to do her job, and that's what she's doing. You know, listen, the only thing that complicates all of this is Donald Trump. This happens every day in America. If you lose a civil case, you get a judgment, you go to court and enforce the judgment, and then you hire someone to collect on the judgment, or you resolve it. So he's being treated like every other American that he allegedly wants to represent.
Let me be absolutely clear about what we are discussing. This is not a fictional scenario where a judge issues some dramatic nationwide freeze on all Trump assets. Those videos exist online and they are labeled as fiction for a reason. What actually happened is far more damaging because it is real, it is documented, and the fraud finding that created this vulnerability is now permanently etched into New York case law, regardless of how the penalty amount was eventually resolved. Here is the sequence that produced this near miss. The New York civil fraud judgment required Trump to post a bond covering the full penalty amount while his appeal proceeded. This is the standard legal mechanism that prevents defendants from hiding or spending assets during the appeals process. The full penalty was approximately $500 million. Trump's operation struggled to secure a bond of that size. Multiple surety companies were approached. The financial gymnastics required to assemble that kind of bond played out publicly as the deadline approached. And the New York Attorney General's office made explicitly clear in public statements that are in the official record that if Trump failed to post the required bond, she was prepared to begin the asset seizure process. Trump Tower, 40 Wall Street, other Trump Organization properties. The legal mechanism for seizing them to satisfy an unpaid civil judgment was available, documented, and being actively prepared for use. The appellate bond reduction to $175 million was the specific intervention that paused the immediate seizure threat. But here is what you need to understand about what that intervention did and did not accomplish. It paused enforcement. It did not resolve the underlying liability. While the appeal proceeded, the fraud findings that created the liability were simultaneously being reviewed, and the ultimate appellate outcome affirmed the liability while reducing the remedy. Fraud finding affirmed. Injunctive business limits affirmed. Penalty reduced as constitutionally excessive. The net result is a permanent fraud finding in New York case law with reduced but real ongoing business restrictions and a documented record that the property empire was one missed deadline away from the seizure process beginning. Let me break down why the Attorney General's specific public statements about seizure preparedness are so significant. When the New York Attorney General publicly says she is prepared to seize Trump Tower and 40 Wall Street, she is communicating that the legal mechanisms for seizing those specific properties have been identified, that the procedural steps required to initiate the seizure process have been mapped, and that the only obstacle between preparation and execution is the defendant's failure to post the required bond. This is not rhetorical escalation. This is the Attorney General communicating institutional readiness to use available legal tools if the deadline is not met. And the specific named properties matter enormously for understanding the brand damage dimension of this near miss. Trump Tower is not just a real estate asset. It is the physical embodiment of the billionaire businessman brand, the building that put the Trump name on the New York skyline, the headquarters, the home, the most visible symbol of the financial empire the brand claims to represent. The Attorney General being publicly prepared to begin the seizure process for Trump Tower is the specific institutional action that would have been the most devastating possible brand destruction event in Trump's entire business and political history, and the only thing that prevented it was the appellate bond reduction. Now let's talk about what the appellate court actually did versus what Trump's operation claims it did. The appeals court threw out the $500 million disgorgement penalty as unconstitutionally excessive, but it did not erase the fraud finding. It affirmed that Trump, his company, and 2 of his children are liable for fraud. It kept injunctive limits on their ability to do business in New York. The higher court saved him on the penalty amount. They did not save him on the fraud label. And the fraud label is what every future civil judgment, every future bond requirement, and every future asset seizure threat will be built on. Because the factual foundation that established the fraud has been affirmed on the merits and is in the permanent case law of New York. The injunctive dimension deserves specific attention. The business restrictions that the appeals court kept in place are ongoing operational consequences that exist independent of the penalty amount. They affect how the Trump Organization conducts business in New York on a continuing basis. These are not a financial penalty that can be paid and discharged. They are ongoing court-imposed constraints on the organization's operational freedom. Constraints that are in place because a court found the organization engaged in persistent fraud, and that remain in place as long as the injunction is operative. A business empire operating under court-imposed restrictions on its New York business activities because of a judicially affirmed fraud finding is not operating from a position of vindication. It is operating under the specific ongoing institutional consequences of the most comprehensive fraud finding in New York civil litigation history. The bond deadline crisis itself is the specific documented expression of a financial vulnerability that the billionaire businessman brand is specifically designed to obscure. The gap between the asset-rich, cash-poor reality of a real estate empire built on leverage and the liquid financial capacity required to post a $500 million bond on short notice. Trump's public net worth claims, the inflated valuations that the court found fraudulent, were designed to project the image of a person with essentially unlimited financial capacity who could meet any obligation from the vast reserves the brand implies. The bond deadline crisis documented the specific reality behind that projection. Multiple surety companies approached. the financial mechanisms required to assemble a bond of the required size, stretching the operation's resources in ways that were publicly visible as the deadline approached. The Attorney General's public statements that she was prepared to seize specific named properties. A billionaire with the resources the brand claims does not struggle publicly to post a $500 million bond while surety companies decline to underwrite it. The bond crisis was the most direct possible documentation of the gap between the brand's financial claims and the operational financial reality, and it played out in public against the backdrop of a civil fraud judgment that had already established those claims were fraudulent. Let me walk you through how civil judgment enforcement actually works in New York, because understanding the mechanism makes the near miss more concrete. When a judgment debtor fails to post a required bond or satisfy a judgment, the judgment creditor can begin a process of identifying, restraining, and ultimately liquidating assets. For real estate assets, the process involves specific steps: liens on properties, restraining orders on sales and transfers, ultimately sheriff sales where properties can be sold to satisfy the debt. The process is not immediate confiscation. It is a legal sequence with specific steps and timelines, but each step generates public record. Each step produces court filings and official government actions documenting the seizure process in ways available to media, markets, and the public. A Trump Tower with a judgment lien and a pending sheriff's sale is a Trump Tower whose status as a viable operating business is immediately and publicly compromised. Tenants, lenders, and business partners can all see in the public record that the property is subject to the enforcement process. The brand damage from the public documentation of the enforcement process would have been catastrophic, independent of whether the process ultimately produced a completed sale. The near miss was not just about the financial cost of losing the properties. It was about the public record of the enforcement process that the bond deadline crisis came within an appellate intervention of generating. The future civil exposure dimension is what makes this near miss most relevant to ongoing accountability. The affirmed fraud finding creates the specific legal foundation that future civil plaintiffs and future state enforcement actions can build on directly. Any future civil judgment against Trump or the Trump Organization in New York can build on the existing fraud finding as established liability rather than litigating the underlying conduct from scratch. And any future civil judgment that Trump cannot satisfy through bond posting creates the same enforcement mechanism, the same Attorney General seizure authority, the same specific named properties available for the enforcement process, the same documented gap between the asset-rich brand projection and the liquid financial capacity to meet immediate large obligations that the bond deadline crisis made visible. The near miss was not a one-time event that the appellate intervention resolved permanently. It was a demonstration of the specific financial vulnerability that exists as a structural feature of the Trump Organization's balance sheet, and that any future sufficiently large civil judgment can activate again through the same enforcement mechanism. The political dimension connects this asset seizure story to the broader accountability pattern. Trump's entire political identity is built around the claim that he is a successful, competent, wealthy businessman whose executive experience and financial acumen make him the right person to manage the American economy. The bond deadline crisis is the specific documented event that most directly contradicts that brand claim in concrete operational terms. It shows the billionaire businessman publicly struggling to assemble a bond that a genuinely liquid billionaire would be able to post without the kind of public financial gymnastics the deadline crisis required. And the Attorney General's specific statements about seizure preparedness for Trump Tower show New York's official law enforcement apparatus treating the brand's flagship property as an asset subject to civil enforcement rather than as the untouchable symbol of financial power the brand projects. The fictional asset seizure videos are dramatizing the emotional and political content of the near miss. The documented record is the actual event whose emotional and political content the dramatizations try to capture. And the actual event, the bond scramble, the Attorney General warning, the appellate intervention, the affirmed fraud finding, is permanently in the case law and the public record. available to every future political opponent, every future civil plaintiff, and every future juror evaluating Trump's financial credibility claims. Let me give you the 4 points that matter most coming out of this near miss. The Attorney General's specific public statements about seizure preparedness for Trump Tower and 40 Wall Street are the most significant single piece of the documented record. They establish that the seizure was not a theoretical legal remedy, but an operational plan being actively prepared for specific named properties. Institutional readiness to execute a legal mechanism is different from theoretical availability of that mechanism. When the Attorney General publicly names the specific building she is prepared to move on, the seizure process has moved from the statute books into the operational planning stage. The bond crisis revealed the specific financial vulnerability that the fraud findings established in legal terms and the near miss expressed in operational terms. The gap between asset-rich brand projections and liquid financial capacity to meet large immediate obligations. A billionaire with the resources the Trump brand claims does not struggle to post a $500 million bond while surety companies decline to underwrite it. The public financial scramble was the most direct possible operational documentation of the gap between the inflated net worth. The fraudulent financial statements were designed to project and the actual liquid financial capacity of the operation behind the brand. The appellate outcome is not vindication. Treating it as one is a specific mischaracterization of what the appeals court actually did. Fraud liability affirmed. Injunctive business restrictions affirmed. 2 Trump children found liable for fraud alongside their father. Penalty reduced as constitutionally excessive. A business empire operating under court-affirmed fraud liability and ongoing injunctive restrictions on its New York business activities because an appeals court found the fraud findings supported is not operating from a position of vindication. It is operating under the specific ongoing institutional consequences of judicially affirmed fraud. The asset seizure near-miss story is the most personally revealing expression of the accountability dynamic because it shows the specific claim most central to Trump's entire public identity being directly and concretely contradicted by the documented operational reality. The billionaire businessman brand is the foundation of everything: the political authority, the economic credibility claims. The bond deadline crisis showed the billionaire publicly scrambling to meet a financial obligation. The Attorney General's seizure preparedness statements showed the flagship property treated as a seizure target rather than an untouchable symbol of financial power. And the affirmed fraud finding established in permanent New York case law that the financial statements supporting the net worth claims that made the brand possible were fraudulent. All three, the scramble, the seizure threat, and the permanent fraud label, are in the documented record now. Not fictional dramatizations, not speculative scenarios. Documented events in the official record of the American legal system, and every future civil judgment, every future bond requirement, every future attorney general with enforcement authority over a Trump Organization property starts from that documented foundation rather than from the brand's own projections of untouchable billionaire financial power. So where does this leave us? It leaves us with a documented bond deadline that required Trump to post $500 million or face the Attorney General beginning the seizure process for specific named properties including Trump Tower and 40 Wall Street, the most concrete near miss in the entire Trump financial accountability record. It leaves us with the appellate bond reduction as the specific intervention that paused the immediate seizure threat, saving him on the enforcement timeline while the appeal proceeded, but not on the underlying fraud liability. It leaves us with the ultimate appellate outcome affirming the fraud finding, keeping the injunctive business restrictions, and reducing only the penalty amount. The result Trump's operation calls vindication and the documented record shows is the opposite. It leaves us with the affirmed fraud finding as the permanent legal foundation that every future civil judgment can build on directly, creating the same enforcement mechanism vulnerability the bond crisis demonstrated. The fictional seizure videos are fiction and they distract from the real story. The real story is that Trump Tower nearly had a sheriff's process beginning against it. that the only thing stopping it was an appellate intervention that saved him on the penalty while leaving the fraud label intact, and that the fraud label in the permanent case law of New York means the near miss was not a one-time event that resolved cleanly, but a demonstration of a structural vulnerability that any future sufficiently large civil judgment can activate again through the same enforcement mechanism the Attorney General was already preparing to use. Stay tuned, because the next civil judgment, the next bond requirement, the next Attorney General statement about enforcement preparedness will be evaluated against the permanent documented record of how close the billionaire businessman's most famous building came to the seizure process that the fraud findings established the legal foundation for, and that the bond deadline crisis brought within a single appellate ruling of beginning.